And our next round of questions goes to MP Duvall. You have the floor for 6 minutes.
Thank you. And I want to thank all the guests for coming here today and giving us some feedback on this important issue. So my first question was going to be to Mr. Powell, because he has mentioned it, and even Mr. Book had mentioned it. But there's been talk about the committee about delaying when the measures of this bill will kick in. And I've heard approximately it's been thrown out there a 3-year delay, but would that be for existing people that are already in the procedures? And I'm only asking that question because if we allow a 3-year delay when this bill will be implemented, the way it's written, to me, that would be a race of applicants of trying to get there before time. So I just want to hear Mr. Powell's comments on that, please.
Yes, thank you, Mr. Duvall. I think when I talk about that, when I look at a 3-year delay or some amount of time, I don't know if 3 years is the correct amount, but there does have to be a reordering of the agreements between the borrowers and the lenders. That has to occur, whatever time that takes. But I wouldn't. I don't like the idea of saying that it only starts to happen after 3 years. It goes into effect now. They have 3 years to make the adjustments so that you don't legally get into the situation of being enforceable for 3 years, but you don't give them 3 years to set new agreements. You get, to enter into long-term agreements that would avoid having to fall under the regime of the law. The regime of the law would be there. You have 3 years to structure yourself to be prepared for it. And I'm not a lawyer that writes legislation, so I don't know how you write that, but that's the meaning that I have.
Okay, thank you. And Mr. Eady, I want to thank you for all your hard work you've done representing the Sears retirees. You're an amazing person, and so is the group that you're working with. And I know that you guys have gone through a hard time. Now, putting the unfunded portion of the pension plan up to super priority and ahead of other secured creditors, as Bill C-253 will be doing, would that have helped save the Sears pensioners?
Yes. The simple answer is yes.
Okay. Then my next question, and there's been some talk of moving up the unfunded part of the pension and of the pecking order, but still leaving them behind the banks. Would that have saved Sears pensioners?
I'm not certain. I don't believe so, because there was really only the super creditors and the rest in this case. The employees were part of the super creditors, and the bank. So I don't believe it would have made any meaningful difference to Sears pensioners. So I don't agree with that process. Pensioners need to be in a place where they're treated at least as equal on the debt that is owed them as other debtors. It's easy to say that all creditors are debtors, but it's a different type of debt that you have with the pension plan. It's a long-term outstanding debt. And so they have to be treated as super creditors to make it meaningful to pensioners, and it would have been meaningful for Sears pensioners.
Okay, thank you. And Mr. Eady, because of the Sears, and I know it was devastating for people across Canada, and it really brought a lot of highlighting out of our current situation that we have. So do you believe that the status quo that we have now, the rules are inadequate, but it was so easy for Sears to go into CCAA and claim bankruptcy to relieve themselves of their liabilities and actually make a profit for some of others?
Yeah. That's a complicated question, Mr. Duvall. It's the situation that Sears found itself in is not unique, but it is substantially different than others' examples like Nortel. The Sears situation was a Pacific business practice that the hedge fund used against the company. There are no laws in Canada that interfere in that process. Should there be? Well, that's a wholly different question for another day. Maybe they should be addressed as well. However, in this case, they did what was legal, and you know, I'm not here to dispute that. What is questionable in my mind is the CCAA, which is now morphed from a restructuring law to what appears to be an orderly bankruptcy law. There's no doubt in my mind that Sears knew they were going to close that business out when they sought court protection, but they used the CCAA laws to be able to get DIP money and to organize it, maybe to the benefit of the company, maybe not.
Okay, and for Ms. Watts, I want to thank you for your work that you do. Do you believe that, and if I heard you correctly, that it is imperative that we deal with this issue, this term of government, to make sure that there's changes to be made that would protect the pensioners that you represent?
Yes.
You're the best. Thanks.
Thank you so much.